difference between design patents and utility patents is a bit confusing, since utility patents can also protect the design of a product. Picking the wrong type of application can set you up for failure before you even begin. So in this video, I'm going to explain what design and utility patents cover, when to use one or the other, or maybe even both, and the differences in cost, the examination process, and the time it takes for the application to actually grant as a patent. So let's start off with some basics. So patents cover utilitarian things, whereas copyrights protect artistic works. So the first thing, if you're thinking about protecting a design, is to determine whether what you have is utilitarian or artistic, or maybe both, and to make sure that you're choosing the right type of protection. So to give you an example of copyrights versus patents, think of physical clothing. So physical clothing, it's obviously very artistic, but from a legal standpoint, it's considered to be utilitarian. So you would have to file a design patent on the ornamental design of clothing, even though it's very artistic in a lot of ways. That being said, if there are logos or patterns that are unique on the clothing itself, you may be able to protect those with copyrights or trademarks. So another example is the famous Brandeer International versus Cascade Pacific Lumber case. And what happened here was there was a guy named David Levine who was the owner of Brandeer International, and he made these ribbon sculptures, and they were sort of these squiggly vertical things. And one day he had a friend over who was a business guy, and he said, "Hey, these would work really well as a bike rack." And so Mr. Levine decided to kind of pivot the company a bit, and so he started to sell these ribbon bicycle racks, and they were wildly successful. A lot of people bought them, and they got so much attention that Levine noticed that Cascade Pacific Lumber was actually copying their design of their bike racks. And so he wanted to stop them. And eventually he sued in court for copyright infringement. And what the court ultimately found was that even though this bike rack was very artistic in a lot of ways, it was still being sold as a bike rack, still being used as a bike rack. And so even though it had artistic qualities, it was still a utilitarian invention. And so it was ineligible for copyright protection. And so he would have had to file a design patent application to cover this ribbon bike rack. So if both design patents and utility patents can cover a design of something, how are they different? Okay, so design patents cover a single ornamental design of an article of manufacture. So as I'll talk about a bit later, the protection is defined by black and white drawings of one single specific ornamental design in a lot of different angles. On the other hand, utility patents can cover systems and methods. So that's sort of a quick way of saying things and methods. And protection is defined by claims that are in the form of words. And let me give you one specific example of this. So take a look at these two claims. One here is a utility patent claim, and this one is a design patent claim. So let me read the utility patent claim. So it's a tool comprising a hammerhead, wrench slot, and first nail puller at one end of an extended shaft, and a second nail puller at a second end of the shaft. So that actually describes this drawing really well, right? But if you look at the design patent, it's going to cover this one specific design. So you could do variations of this, and if it didn't have close to or this exact same design, it wouldn't be infringing. Whereas to infringe the claim of the utility patent, which is in words, you could obviously have a lot of different variations of, say, what the hammerhead looked like, what does the wrench slot look like, what does the first nail puller look like. So all those things just have to be present in the design of the product. It doesn't need to have this specific one design. So the takeaway here is that utility patents tend to be more powerful and can be better because they cover a lot more variations and they're harder to design around, but utility patents are a lot harder to get. So a design patent may be a good option if you're not able to get a utility patent. So for instance, if what you were to claim in the utility patent would be considered not new or it'd be considered obvious in view of the prior art, you may want to go with a design patent because it's a lot easier. The threshold to get a design patent is a lot lower. You almost have to have the same exact design in order to get rejected, in order for the examiner to say this design is not new or it's obvious in view of the prior art. So as you can probably imagine, design patents are not always that useful where there's going to be a lot of different variations of your product, or where it's easy to design around, or where there's not one specific design that's really important. And also design patents won't cover functional designs, only ornamental designs. So design patents are good for designs where what I typically say is where it's something that's important to the the branding of the product, something that makes it distinctive. It's almost like trademarks in some ways, where having something that is a design, an ornamental design that is really important to the product standing out, that's where design patents tend to be good. Now, what are some examples of cases where you would want to use both a utility and design patent? So for instance, if you want to protect a method of how something is used, but there's also an ornamental design aspect of it, and you want to protect the physical configuration broadly, you may want to file a utility patent and a design patent on the ornamental aspects of it. Sometimes it's important to do both. Also, if you think that getting a utility patent may be difficult, filing a design application may be a good way to have a backup in case your utility application gets rejected. So let me go back to the example of the wrench that I had. So you have these word claims, right? And so, you're going to have to convince an examiner that what this claim says in these words, it is new and non-obvious over the prior art. With something like this, it may be difficult. There may be a lot of things that are really similar, and you might be rejected. You may not be able to get over those rejections. For those sort of consumer products, that is certainly a possibility. So what you may do is actually file a design patent as a backup. And so at least you would then be able to say that you're patented. You would be able to stop people from directly copying what you're doing. And while design protection is typically very similar to what that one design is, you do have some wiggle room. And so a lot of times you may still be able to stop people from doing things that are similar, but probably not as broadly as you would if you were to be able to get a utility patent. So let's discuss the differences between design and utility applications, including the examination process and cost, because they are very, very different applications. And knowing the difference between them may make you want to choose one over the other, or maybe even choose both. So for utility patents, there are two ways to start the examination process. One is to start with what is called a provisional patent application. And provisional patent applications, they are just a placeholder. They only last for 1 year. They automatically expire at the end of the year, and that term cannot be extended. So then you have to file a full non-provisional patent application. This is the formal application that has the formal drawings, the formal text. It has to have a claim section. And this non-provisional application, that's the one that then will wait in line for 1 to 3 years before examination begins, which starts a negotiation with the examiner, this back and forth, where you have to convince the examiner that what you have is new and non-obvious over the prior art. Hopefully the examiner will be convinced at some point, the application will be allowed, you'll pay an issue fee, and then the application will grant as a patent. So that's the example of starting with a provisional application and then filing a non-provisional utility application. On the other hand, you could just start with the non-provisional. You don't have to start with the provisional. You could just start with that full non-provisional application. But what I typically say is that for startups, it almost always makes sense to file the provisional application first. There's a lot of reasons. Check out some of my other videos that discuss that in more detail. It's a bit out of the scope of this video, but just realize that there are two ways to start the utility application process: provisional, or you can start with the non-provisional, and starting with the provisional tends to be better for startups. So for design applications, there is no such thing as a provisional design application. You have to start with the non-provisional patent application. So design applications, they don't have a version of a provisional where it's just a placeholder that only lasts for 1 year. You have to file the full non-provisional design application that has to have formal drawings, that has to have a formal claim section. But luckily, it's not as expensive and not as difficult as a utility application. So design applications, I'll show you some drawings. They're very simple in a lot of ways. They do have to be line drawings, and they have to be very exacting, but you just have these line drawings in a lot of different perspectives from a lot of views, and that's really the claim of what it is. So in terms of the description, usually it's going to be 1 page. It's going to have a description of really basic description of what those drawings are, and there's going to be one claim, and that claim is going to say the ornamental design of XYZ as shown and described here, and that's all it really is. So design applications are extremely simple. A lot of times, it's probably going to cost you maybe $2,000 to $6,000 to draft and file an application if you're working with an attorney. On the other hand, utility patents are very, very complex. They tend to be very, very expensive. That's why it's usually good to start with a provisional application. Provisional applications don't have to have formal drawings, don't have to have formal description, don't have to have a formal claim section. So starting with a provisional utility application can be a good way to save costs early on, be able to test the waters, be able to get patent pending status, and be able to get investors, start attracting customers, and start getting revenue before you have to pay all the money for the expensive non-provisional application. So utility applications, like I said, they are very complex. They have numerous drawings. A lot of times you're probably gonna have at least 5, maybe 10 line drawings. They're gonna have all these figure numbers pointing to aspects of it. And the description is going to be a highly technical document. So that's why a patent attorney like me, I have to have a technical background. I have to understand the technology of my clients as well, if not better than them. So I have an undergrad in biochemistry and molecular biology, a master's in electrical engineering. So I do a lot of computer stuff, a lot of robotics. And so I will draft these 20 to maybe 100-page documents that have all the really highly technical descriptions of how these inventions are made and used. That's one of my favorite parts of the job. I like to geek out on technology, like to hang out and write about robots all day. They also have to have a complex claims section, and the claims are the metes and bounds of what is actually owned by the patent if it were to grant. And so these are things that you almost certainly have to have an attorney do. Yes, you can kind of try to hack through it yourself, but because the claims are so important, it's best to have an attorney do it. So all these things are what makes a utility application really, really expensive. And what you're typically looking for in terms of cost is going to be anywhere from $10,000 to maybe $30,000 to just draft and file this non-provisional application. So it's going to be pretty expensive. Also, in terms of the examination process, utility applications, so like I said, you file your utility application, it waits in line for 1 to 3 years before examination begins. And with utility applications, rejections are standard, right? You're almost certainly going to get rejections. It is a natural and expected part of the examination process. Just like if you're going to go to a flea market and you're naturally going to haggle with people, that's the way the examination process tends to be. I'd say 95%, maybe more of applications get filed are going to be rejected at least once. Usually there's multiple times where you're going to get rejections, you overcome them, there's new rejections, and it's going to go back and forth with the examiner for a while. That can be expensive. A lot of times the cost of doing one of those responses is going to be anywhere from $2,000 to $10,000. And so if you're going back and forth with the examiner multiple times, that cost is going to really increase a lot. And that's not included in the original $10,000 to maybe $30,000 to draft and file the non-provisional application. So utility applications, as you can see, they're really time consuming. They are really expensive. Whereas design patents and design patent applications, they are way simpler. So like I said, it's just one page of description, a bunch of drawings from different perspectives. That's not going to cost as much. It's going to maybe be $2,000 to $6,000. And then it's not going to take as long for it to be examined. Usually it's only going to be 6 to 24 months before examination begins, compared to the 1 to 3 years for a utility application, a lot longer. Also, the examination process itself, when it begins, it's going to be a lot simpler. So whereas in a utility application, there are almost always going to be prior art rejections. The examiner is going to say, no, that lacks novelty, or that's obvious in view of the prior art. With design applications, prior art rejections are fairly uncommon. A lot of times, all you're going to get is rejections about the drawings, that the examiner wants some lines to be a different way, or wants some changes in the text and wants some little nitpicky things to be done. That's usually what goes on in design applications. So the cost of doing a response to that tends to be a lot lower. You're probably only looking at maybe $2,000 to $5,000 to do a response. And usually that's going to take care of things. You're not going to have this back and forth and back and forth. And so once examination begins within 6 to 24 months, usually you're going to be able to get an issued patent within a few months, at the very longest, maybe within a year or so. So the time to getting issued patent is a lot shorter, which can be beneficial as well. And that may be a reason why you file both a utility application and design patent application, because you may be able to get your design application sooner. Then you can say that you're patented and hopefully dissuade people from copying, license the idea, things like that. And then later on, when the utility application is coming up for examination, and once it's gone back and forth through examination, then you may realize, hey, I'm fine with just the design protection. This is too difficult and expensive, and you may just give up on it. Or you may say, hey, well, yes, I have this design protection, but I want to go for broader protection. It's really important to me. You may then realize that it's important. You may decide to battle that out and get that broader protection. So I want to give you some insider tips about filing design or utility applications, things that I've learned over my 20 years of being a patent attorney and doing this full time. I do a lot of design work, do a lot of utility work, of course. So the most important thing with both utility applications and design applications is to file them before you make any public disclosures, public uses, or offers for sale. And the reason for that is that patent rights start to be lost upon a first public disclosure, public use, or offer for sale. So definitely file your patent application before you do any of these things. Otherwise, your patent rights could be forfeited. Also, you want to wait and file your design application until the product is finalized. And I see this a lot where people say, oh yeah, this is what the product's going to look like. We just need to send it to the manufacturer, and then that's it. That's going to be really simple. And then what happens is we file this design application on the CAD that they have, and then a few months later say, well, we took it to the product designer or the manufacturer, and they kind of made some tweaks. It wasn't going to work out because we had to change the shape of things for it to be manufactured correctly. And so now suddenly their design application is worthless because it doesn't cover the product that they are actually going to make. So wait until you have the final product before filing your design application. Otherwise, it may be worthless and not actually cover the product, and you may be wasting a lot of money. Also, it's better to wait to file a utility patent application as well. It's better to wait until you're actually going to make public disclosures, public uses, or offers for sale, especially for startups, because you're going to know a lot more about the invention. The details of patentability tend to be in the specific details of the product as you've developed it. It's not going to be the broad idea. So it tends to be better to wait until you know those details. Also, it's better to defer costs instead of filing too early. And so, for instance, like what I tell startups is start with a provisional application. They file the provisional. That gives them 1 year to test the market, be patent pending, hopefully attract investors. And it helps to delay that year as long as possible. It's better to delay filing the provisional so you have that year as long as possible, right? So you want to defer the cost of having to spend a bunch of money on that expensive non-provisional, the examination process, until you know that it's worthwhile. You ideally want to have revenue from the company, have investors or other strategic partners. You want those folks paying for the utility application drafting process and ideally for the examination process as well. Now, one of the best insider tips about design applications is to use dashed lines to make the protection broader. And this is one of those newbie mistakes that I see people make if they're filing themselves, or even patent attorneys who don't really understand design patents. What they do is they draw the whole thing in solid lines, and it makes it really hard for people to infringe the design patent. So let me give an example. And this is a design patent by Bentley. And you can see here that a lot of the car is shown in dashed lines. And what this does, this effectively disclaims those things. And only the grille and the lights are shown in solid lines. So this actually makes it easier to infringe this design patent. So for instance, if you were to have all of the car and also the grille and the lights shown in solid lines, somebody would have to have the specific body shape and the grille and the lights. They would have to have all those things in order to infringe that design patent, which is a lot harder and in a lot of ways is kind of worthless because that's not what they care about. They don't want people copying the grille. They don't want them copying the lights. So that's why in this example, only the grille and the lights are shown in solid lines. The rest of it is shown in dashed lines, which makes those just sort of environmental things. And that is a really simple way to broaden protection for design applications. So when it really comes down to it, whether you file a utility application or a design application, or maybe even both, it comes down to the details of the specific product. So it's critical to talk to a patent attorney about your specific product, about your specific business plan. All of those things are going to inform whether you need to file a utility application or a design application. Don't try to do these things on your own. That's always the thing that I see people make a mistake with is that, hey, I figured it out and I file it, or they file this design application and then it's totally worthless. It's not done correctly, so it's going to fail in examination. And even if it went through, it's going to be effectively worthless. It's not going to protect protect the invention how people wanted it to. So it's really simple. Talk to a patent attorney about strategy. A lot of times you can do that really inexpensively or free. Usually a patent attorney can look at it and it's going to be a couple minutes and they say, okay, here's what I would do. Here's how I'd protect things. Here's what's going to be protected by a design patent. Here's what's going to be protected by a utility patent, or design patents are going to be worthless for this. It'd be really easy to design around. Focus on a utility application. That's going to be better. Talk to a patent attorney. That tends to be a lot better in doing strategy for design patents and utility patents.